Well, there you have it. Hello and welcome to the Fox Nation special Trump on Trial Live. I'm your host, Greg Jarrett. Thanks for being with us today. Well, the former president speaking after court just now, the day has ended. The prosecution's star witness, Michael Cohen, took the stand today to testify on Trump's role in the alleged hush money payments to Stormy Daniels. Let's get right into it and bring in my panel to break down what has unfolded so far today. Joining me now, former federal defense attorney Ronald Chapman. Thank you all for being with us. You know, Ron, with gentle prodding from the prosecution, Cohen did say in reference to the Stormy Daniels payments, which, as I've said ad nauseum, are perfectly legal. Non-disclosure is perfectly legal. He said, well, Trump was concerned about how her alleged story might impact the election, which does dovetail with the prosecution's theory that, he was trying to influence the election. Well, that falls into the category of so what? Because he paid for it with his own personal funds, not campaign funds, which means it's not a violation of the campaign finance laws, which is why the DOJ and the Federal Election Commission said, no crime here. This was perfectly legal. So even that aspect of the case doesn't support a crime, does it?
No, you're absolutely right. And I think there's another observation we can make here. That characterization, the intent to defraud the American people, is the same thing that Jack Smith is using to support his January 6th prosecution. And where this kind of marries up is this concept that you can commit fraud by depriving people of information, knowledge of a Stormy Daniels affair before they cast their vote, which makes no sense, is not part of any law that I have ever read or any case law that I've ever read. And so that theory of fraud just doesn't really add up, but I think it's for a political purpose. It's to cause the American people to believe that they were defrauded and could be defrauded if they cast a vote for Donald in the future, which tells us all we need to know about this New York prosecution. Tie Donald Trump up for as long as you can, prevent him from campaigning with these ridiculous theories. But even if that doesn't work, get as much salacious information out there as you can to prevent people from casting a vote in his favor. And that's called election interference.
Because it's fundamental law that the guilty plea of one has no force and effect or impact on the guilt or innocence of another individual. So I know that Katie's right. They're trying to imply this, and they will emphasize it, but people, for a variety of reasons, do sometimes plead guilty to crimes they didn't commit. They even plead guilty, as in this case, to a non-crime. Cohen did it to shave time off of his sentence to curry favor with prosecutors, which, by the way, is a common occurrence in American jurisprudence, isn't it?
Well, that's exactly right. So here's how this worked with Michael Cohen. The feds pursue an indictment against him for a range of offenses. I believe there was $2.3 million worth of fraud for a New York taxi stamp issue and other allegations stemming from a large amount of conduct that he was in fact guilty for. And then they snuck in there the federal campaign violation and included that. And for the purposes of negotiation, Michael Cohen then has to sit and think, in order to defend Trump, do I want to go to trial on these other things that I'm actually guilty for? And he makes the easy choice. He cuts a deal. But the thing is, by the time when it comes time for him to start cooperating and providing information, even the federal prosecutors in that case decided that Michael Cohen did not have enough credibility to testify or even talk about Donald Trump. Congress later determined that when they found that he lied to Congress. In fact, there's even a more recent letter from Congress to the Department of Justice highlighting all of Michael Cohen's lies. And so, yeah, he cuts a deal to save himself, but it wasn't for this conduct. It was for a range of other conduct that he was involved in, and that was, I suppose, a good choice for Michael Cohen.
Ron, Michael Cohen has been making a living off of trashing Trump. He hates him. He despises him. And he's been trolling for dollars. It's his livelihood now. And I'm going to show on the screen some of the TikTok stuff that Michael Cohen has been doing. Okay, Ron, you see those clips and you think to yourself, what a vile, loathsome, awful human being this guy is, which matches the testimony before he took the witness stand from other witnesses who just had terrible things to say about him. If you're a juror and you see those clips, and I'm sure they're going to play those clips on cross-examination, I mean, game over, isn't it?
Oh, absolutely. Prosecutors will tell you this, and I'm sure in this case they'll try to insulate themselves a little bit by saying crime doesn't always happen with angels in the room. Sometimes it takes bad people. And they'll try to walk away a bit from Michael Cohen's conduct and his prior TikTok statements. But the reality is, when a prosecutor puts a witness on the stand, they are somewhat vouching for that person's credibility and lack of bias. And so people will see Michael Cohen on cross-examination, and they will look at the prosecution table and say, you called that person to try to speak the truth in this courtroom, and we're going to hold you to it. And when it's highlighted to the jury that he's been on TikTok, that he's trying to make money, that he has a T-shirt that shows Donald Trump in jail, I've never seen a witness in all of my years of defending cases that had so much evidence of bias that the prosecution chose to call. And let's not even get on the Weisselberg topic, because that's really going to be the missing chair here. So they choose Cohen, not Weisselberg, and clearly this is why, because he's the one with the bias to tell the narrative that they need, and that's inappropriate.
Yeah, I mean, it would not have worked out for Alvin Bragg to put Weisselberg on the witness stand. Ron, a competent, fair judge would have long ago dismissed this case saying, you don't have the authority to bring this. And even at the beginning of the trial, in the first week or two, a competent, fair judge would have said, I'm not going to allow all this irrelevant, prejudicial information. You're just trying to smear the defendant with non-crimes. Now there's an opportunity, as we approach the end of the prosecution's case, for the judge to step in and say, you haven't presented sufficient evidence to prove the crimes that you allege in your indictment. I'm hereby issuing a directed verdict in favor of the accused, motion to dismiss, and so forth. I've heard a few people say maybe the judge will seriously consider that. Given his past conduct, I say there's about a 1% chance of that. How do you handicap that?
Well, I think it might be slightly higher than 1%, but not much. And I'm not sure of the specifics in New York, but generally, and especially in federal court, a judge will reserve decision on that motion until after the jury comes back. And hopefully with maybe about 5 minutes of introducing themselves and a bit of chatter, they come back with a not guilty, and we never know how the judge turns out. That's really how this should be handled. But, the reality is Alvin Bragg just needed to plead enough to get himself a jury trial, because that furthers the purpose, the combined purpose of binding Donald Trump up through this process and spewing bad information all over this election. And that will have been accomplished by the end of the case. Hopefully a quick acquittal brings some justice, but if not, I would expect this judge to fully consider that motion to dismiss for one simple fact and one simple fact only. They didn't show the underlying crime and didn't prove it. And going back to that audio tape, there's something very interesting and dispositive in there. Michael Cohen's about to say, I got, and he catches himself. What he was really about to say was, I've got you. I'm going to take care of this. But he stops short because he knows he's being recorded. And I expect that'll be argued in closing.
Yeah. Ron, great discussion. You guys are pros. Thank you for taking the time for joining us today.